Hello, this is Alexander Cross, criminal attorney here in the San Francisco Bay Area. Be sure to subscribe to our channel, Law Offices of Cross and Associates, if you'd like to learn more about criminal defense. We received an interesting inquiry here on our YouTube channel. This has to do with somebody who's refusing to do a DUI test. Let's see. In a traffic violation, I refused to do the alcohol test. I drank 5 beers. How could this affect me? Well, first let's talk about those 5 beers. I'd like to know how much you weigh, but unless you weigh about 300 pounds, that 5 beers, provided that you drank it pretty recently, is going to be more than enough to have you over the legal limit. See, what I have here is a chart from the DMV indicating roughly the amount of alcohol that you would have to have in your system and still be under a 0.08. If you look here at 5 beers, which is what this person is requesting about or asking about, basically, once you're at 240 pounds, a male 240 pounds would still be at a 0.12 blood alcohol level, 0.12. So really, and also for every 40 minutes, the blood alcohol level only reduces by about a 0.01. So essentially, you know, drinking 5 beers, you would have had to have allowed a good 9-10 hours pass, provided that you weigh 240 pounds. You would have to weigh significantly more in order to be under the 0.08. 5 beers is actually quite a bit with regards to blood alcohol level. I understand that most people will say, what are you talking about? I don't feel drunk with 5 beers. Okay, well, maybe you might not feel drunk with 5 beers, but that doesn't really matter. It's not based on how you feel. Now, regardless of how hammered you might be, you still have the right to refuse a field sobriety test at the detainment. At the detainment. You don't have to blow in the alco test device. You don't have to do the horizontal gaze and nystagmus. You don't have to do these things. But once the police say, all right, that's it, we got to arrest you, we're taking you down to the station, we're taking you down to the local jail, at that point, yeah, they will ask you to do another field sobriety test, or they'll ask you to just do a chemical test, either breath or blood. If you refuse that, they will read you something called the Trumbetta advisement to basically let you know that you don't have the right to refuse, because since you're driving on the roads here in California, you've already given implied consent. So if you refuse to do that, you will essentially be charged with a refusal, which basically amounts to an automatic DUI. And not only that, but your license will be suspended for an entire year without the ability to obtain a restricted license. That's a hard 1-year suspension. And if they get you driving while your license is suspended under Vehicle Code Section 14601.2, you can get up to 6 months in the county jail. So please don't do it. Regardless, if you'd like to learn more about criminal law here in the San Francisco Bay Area, be sure to subscribe to our channel, Law Offices of Cross and Associates. But if you've been accused of a crime and need representation in court here in the San Francisco Bay Area, give us a call at 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we're going to be discussing somebody who would like to no longer be responsible for posting his nephew's bail. See you on our next video.